Everybody hear me? I'm here. I'm Jessie Hanforth-Combe. I'm the Deputy Director of the Office of Block Grant Assistance, and we manage the CDBG program. I'm seeing a question actually. Can somebody type in the thing, can you hear now? I'm seeing questions about whether they can hear anything on the phone or not. People can hear, good, great. Okay, so what we're doing today is more of a clarification to procurement requirements for states and less of an update. But what we wanted to talk to you about is, this is a brief presentation so that we can help state CDBG grantees understand the choices that they have to make regarding procurement and know where additional resources are. It's come to our attention because of a couple of fairly contentious audits that we were working through, that there might be some lack of clarity out there, and we wanted to help with that. This is not in-depth training on procurement, CDBG procurement. We do have Paul Webster of our Financial Management Division and James Heyman of our State CDBG Division to help us later with our questions and answers if there's anything that comes up that's not directly on the topic. They're much more expert on that in general. So what we're going to cover is learning from the audits, why we do this, and then just a brief overview of the recent policy clarifications. And I have a fair amount of text on the screen because I wanted to list from, we have both audit responsive material and we have some legal opinions that I think really clarify a couple of points. So in general, we learn from audits. It's something that the Office of Inspector General recommends to us when patterns emerge in audits or when contentious issues get wrestled with. We realize that there may be some clarification. Even if we don't need to change a requirement, we do need to explain exactly what it means. And so that's basically what we're doing today. And the background on this particular issue is that CDBG disaster recovery grants are made based on special supplemental appropriations that occasionally have some additional material in them and overlays on the CDBG program. And one of the recent overlays was that the Secretary of HUD was going to have to certify that the grantee had in place proficient financial controls, including procurement processes. And so HUD published Federal Register notice for the first one, and there have been subsequent notices for other appropriations. For at least, other appropriations. And we describe the requirement and what documents a grantee needs to submit so that HUD can make its certification of proficiency. Then we designed a checklist, and we have updated it, that so we can review for proficiency, and then HUD makes the certification and followed by making the grant. So that's sort of how it works. It's a little different from regular state CDBG because we don't certify your financial proficiency, but because of this overlay, it raised some issues around procurement that do have some applicability potentially to state CDBG. So we wanted to come out and explain both for DR and potentially for state CDBG. So we got into a disagreement with the Office of Inspector General, which happens occasionally. There's a process where we elevate it and basically discuss it, argue it out. The general counsel gets involved, and that's happened with a couple of audits. And so I'm going to talk narrowly about the issues raised by those audits. There may be other issues related to these procurement matters that come up, and we'll keep you updated as it goes. So just sort of walking through the pieces of the procurement requirements I specifically want to talk about. State CDBG regulations apply to CDBG-DR grantees unless waived, and the procurement section of the CDBG-DR notices and the regs expressly let state grantees use their own procurement requirements if they choose. A state must establish fiscal and administrative requirements for procurement, well, in general, but also for procurement specifically. As a separate flexible requirement that states can use procurement requirements applicable to their own funds adopt new requirements specific to the grant in question, or apply the federal financial requirements. And one of the discussed points on audit situations was if the state applies the federal financial requirements, the regs say that the state is permitted but not required to adopt each subparagraph of the federal procurement regulations. And that was a key point in determining the overlay on the review standards for proficiency. If a state adopted all the subparagraphs, it was clear that the state had to have policies and procedures to meet all the subparagraphs just the way an entitlement would, and follow them. But if the state did not adopt all of the subparagraphs and only adopted the top line thing that it was going to follow, at that point it was 8536A, then it would actually be following its own requirements for non-federal funds. So HUD's review, it's our checklist, brought the questions up because we said we were looking for whether the state standards were equivalent, and at one point we used the word align with the regulations. And one way of looking at this was equivalent meant that there was a state standard that matched every subparagraph of the federal standard. Another way of looking at equivalency and alignment is that you're going to have the same or similar effect as, and results in procurements based on fair and open competition. And that's where the legal opinions came down. They said that equivalent in this case was always intended to mean it meant having the same or similar effect as the federal regulation, which means that it needs to result, whatever the state standards were, policies and procedures, had to result in procurements based on fair and open competition. So things that were designed to cut off competition would not be equivalent, but if you were trying to achieve fair and open competition, not having a separate matching policy for every subparagraph was okay. And this is a case-by-case thing. It's sort of an emerging policy area. We do have some cases, and if you're a DR grant, disaster recovery staff, our disaster recovery division, your assigned grant manager can help you out with this. But one of the things we wanted to bring to your attention is that we do have some tools that can be very valuable. They're tools that actually HUD uses to monitor states or to review for financial proficiency. And we're finding that grantees who use these guides to check their own compliance, and these guides have been updated for 2 CFR 200 now, so they can help you in the state CDBG program, and not just in DR, to review your standards. You can use the financial proficiency checklist and take a look at that and look at what documents the Federal Register notices say to submit and get an idea of, you know, what it takes to be sure you have financial proficiency at the level that we're looking at as a grant overseer. And also the HUD CPD monitoring handbook has been reissued and updated. It has all the Part 200 citations alongside the Part 85 citations. And so you can look at Exhibit 4-7 from the monitoring handbook, and I have the link here, and we'll be posting this. And you can take a look and see whether you are equivalent, you know, whether you've met the requirements. So that's really all I wanted to share with you today. Directly was just to call attention to this area where we're having this discussion around equivalency and alignment, and make sure you know this is going on and give you some tools to be able to look at your own records and your own record systems and your policies and procedures and make sure that you are in compliance. So with that, we can move to questions that you may have about this topic or procurement, and we'll try to answer the questions. Chantel, do you want to come on and tell us how we're going to do this?
Sure, thanks. Well, so for any content-related questions, we ask that you send them through the Q&A box. And if you do not see your Q&A box on the right-hand side of the screen, on the right corner, you should see an icon that says Q&A. Click on that box, and the Q&A box will automatically appear in your toolbar. So again, that's all content-related questions through the Q&A box, and send them to all panelists. Jesse?
Okay, so I only see one question, and Tyler Bridges, I believe, is on in the background, is going to try to sort this out. I see, actually I see a state question and an entitlement question. There's a question regarding subgrantees and what applies to subgrantees. I believe it's a Part 200 question. So if they get CDBG-DR funds funneled through the state, the notice, I believe, speaks to, if you're treating them as subrecipients, what you're going to have to do under Part 200. If you're doing a standard method distribution, how would it work in state CDBG, James? James is here with me. James Heyman's going to come take a swing at this. What applies to state grant recipients?
Well, the state's responsible for designing the procurement policies and procedures for its subgrantees. Now, I will tell you, if you go to 2 CFR Part 200 and you start looking at pieces to adopt out of there, if you look at 317, the first part of that talks about the state itself and what applies, and the second part of that mentions that all of that will be applied to your subgrantees. So you have to be careful when you look at 2 CFR Part 200 in that section that you don't inadvertently apply a policy to yourself or to your subgrantees that you don't want to. So again, that's your requirement, is to have not only your own procurement policies and procedures, but the ones that you expect your subgrantees to follow as well.
Okay, and I see a couple entitlements, and Charlotte asking, the equivalency thing and the alignment thing doesn't apply to you? No, but if you want to use the monitoring handbook, exhibit, I want to say it's Chapter 3, but I could be confused. There's an exhibit for entitlement financial management that includes all the dual citations. You'll see Part 85 and the 200, so that you can check yourself and make sure you've switched over all your documents. The subrecipient management one also has a review for subrecipient agreements, so you can check that you've updated all your agreements properly. There's another state question here for you, James. If a state previously adopted Part 85 in entirety but now would like to consider adopting parts or none of 2 CFR 200, how do they document their adoption?
Well, you have to have your own policies and procedures. So even if you were to actually adopt all of the 2 CFR aspects of it, you would have to have in your policy that that is what you were doing. So in order to kind of document that, it's the same thing, where you just have your policies and procedures for your program, and you just state in there what you are not adopting out of 2 CFR Part 200. But again, I would be careful of looking at 317 and a couple of the other ones. You want to really take a look at what's in there and see if it's going to apply or not going to apply to you or your subgrantees. So if you have questions about what you want to adopt out of there, I would send them in through your field office.
Okay. Let's see. This is starting to go fairly fast. Does CDBG require nonprofit organizations to request 3 bids prior to the procurement process? Paul, are you there?
Yes, I'm here.
Paul Webster, what do we require for nonprofit organizations? I'm assuming that they got a grant from a state, so that would be CDBG-DR, to request 3 bids prior to the procurement process. I think that one needs some unpacking.
There's no, if they're following the Part 200 or the Part 85 requirements, they're not required. There's no requirement for 3 bids. I believe in Part 200, when it talks about seal bid methods, you use that when it's appropriate. and you expect to receive 2 or more bids, but you're not required, there's no 3 bid minimum.
Okay. Those of you that are asking about the timing, when you received your DR funds from HUD, before the uniform guidance or after, the notices, I believe, state what applies to your grant. There's too many different appropriations out there, and I'm not exactly sure what the cutover timing is for the DR grants. I'm sorry about that. We'll refer that one to our DR staff. Tyler can make sure that someone gets that answer out.
Yeah, didn't we? It was in the CPD notice that applies to all 3 appropriations, or the state entitlement and disaster.
Okay, the most recent, yeah. Okay, so there was a notice out about when the cutover happens. Yeah,
I'm pretty sure that if you received your grant award after January 1st of I think it was 16, then 2 CFR 200 applied. But I'll go back and make sure I get the CPD notice.
Perfect. Okay. Here's an interesting one. How could or would the use of GSA pre-competed contracts for goods and services meet the equivalency procurement test? Any of these contracts and pricing can be accessed by state and local jurisdictions. This is a completely separate topic, but one that we've actually been discussing here because it actually is getting to be more common in disaster recovery because GSA has been expanding its portfolio. James, do you know the answer for is there a regular CDBG answer?
For regular CDBG, we would look to what was in Part 85 where it talked about using agreements like that for economies of scale for procurement practices. In that case, if you actually belong to that group or subscribe to that group, you can use those agreements as long as you put in the CDBG requirements in your package that you put out the bid. And some of those will go out on Demand Star or some of the other subscription services.
Yeah, so you don't want to leave the CDBG requirements behind. We're not quite uniform with everybody else. Paul, do you have anything to add on that one?
No.
All right, do we have any, we got somebody saying they were told at a recent HUD seminar that if they adopted a part of 2 CFR 200, that the other sections of 2 CFR would apply for states?
If you go into 570-489, which is the admin requirements for the state, we have in there what actually applies to our regulations in 2 CFR Part 200. Anything beyond that would be of your own choosing. But again, I would be cautious in terms of adopting things out of 2 CFR Part 200 to make sure you read an entire section before you do that, because there are caveats throughout there that if you take one piece of it, then the whole actually applies. So just make sure you read through the entire section first. Just like with a procurement, if you take a piece like 319, you're actually adopting 317 as well, which means you're taking all of the procurement section out of there.
Yeah, so read carefully and read the intersection between the 2 regulations, the one for the CDBG program and 2 CFR 200. Okay, do we have any other questions? The thing has stopped scrolling on me so I can actually read. Does anybody out there have any other additional questions on this? Let's see. We don't usually release copies of our legal opinions, but I can check. They're very case specific, and that's why we were trying to extract just the lessons for this. It isn't very common if we don't have a nationwide kind of legal opinion to release it. But we will put the slides up for this presentation as soon as they're 508 compliant. So we have does 2 CFR 200 apply to RFPs that are for application and grant management or engineering services or state subrecipients? That is an interesting intersection question. It almost has to be CDBG-DR question, and I believe there's a case moving in that space. I don't have the answer to that question. Tyler, that one we're going to have to, I believe that Steve Higginbottom is working on this one.
Okay.
The general applicability is as we have described. The trick with DR, disaster recovery, is that grant management and engineering services may be covered by the grantee requirement that they can't outsource grant management. They have to stay in control of their own program and have the oversight responsibility. They can't source it out. So that question intersects with that policy call that's being made about exactly how far can you go.
Yeah, the only other piece we have on that is in, for the state CDBG, is in 570-489G, which is the procurement requirements. At the tail end of that regulation, it says that the subrecipient, which would be who your subgrantee actually uses if they use a subrecipient, and contractor determinations are to be made in accordance with 2 CFR 200-330, which is the only piece that we apply that may come into play on that.
Okay. And then one of my all-time favorite questions that I know Paul has answers for. What if a homeowner is getting quotes from contractors for repair work that will be paid with CDBG-DR funds? Is the homeowner required to follow CDBG-DR procurement requirements, and should CDBG compliance provisions be included with the resulting contract? I am assuming with this question that the homeowner has the contractual relationship with the contractor. Paul?
Well, the requirements only apply to non-federal entities, and a homeowner who is receiving a grant or a loan from a grantee to carry out for rehabilitation wouldn't be included in the definition of a non-federal entity. In other words, it's not a subrecipient. So they're really not subject to the Part 200 or Part 85 requirements.
That was a good one. That's a question that gets answered, asked and answered fairly often in different angles. Thank you. Does anybody else have any other questions? All right, going once, going twice. Let's see, I'm seeing somebody asking, will we do a webinar for entitlements on procurement? Not planning one right now, but we can. We can add that to the queue. We have one in combining. This is the question I thought it was about combining application and grant management or engineering services in a single RFP or RFQ as applicable. That one I'm going to have to set aside. I'm aware that question is moving, but I'm not prepared to handle it right now yet. DRSI is definitely working on it. So a business receiving DR funds, do they have to follow a procurement process? I'm assuming, again, the business is the beneficiary. Paul, I assume that's the same answer as with a homeowner, right?
Now, if they're not considered to be a subrecipient, then they're not subject to the requirements.
So there we go. Okay. Chantel, do we have any wrap-up business here?
No, that's all on my end.
Okay. We say thank you very much for participating today, and we look forward to getting this posted. If you have any additional questions, talk to your HUD representative or enter a question in the HUD exchange. Thank you all.